We are now shifting gears from the rules of specialized relevance, which I call the SAPI rules, to the rules related to character evidence. I wish this meant that we could shift from sappy to happy, but alas, the character evidence rules are complicated and cumbersome, so happiness is perhaps not the first thing that comes to mind when tackling this issue. Nevertheless, the approach to character evidence in the federal rules resembles that of specialized relevance. That is, certain uses of character evidence at trial are so wrought with the potential for prejudice and have such limited probative value that the drafters of the federal rules deemed that evidence inadmissible. Specifically, evidence of a person's character may not be introduced to show that a person acted in accord with that character trait on a particular occasion. Professor George Fisher calls this the character propensity ban. What's the rationale for the character propensity ban? Again, limited probative value and a high risk of unfair prejudice. Let's say that a party in a criminal assault case, a famous former boxer, has a reputation in the community for being violent. What could be the problem with letting prosecutors introduce this general reputation evidence at trial? First, just because someone is generally violent doesn't mean that the person was violent on the particular occasion that gave rise to this case. Therefore, the evidence has limited probative value on the issue at hand. Second, hearing about a person's generally violent character might greatly prejudice the jury against that person. Therefore, the evidence carries with it a high risk of unfair prejudice. The general principle underlying the character propensity ban is contained in Federal Rule of Evidence 404A, which provides that evidence of a person's character is not admissible for the purpose of proving action in conformity therewith on a particular occasion. Rule 404A contains a number of exceptions that we will explore in more detail later on.